arranged to have a couple of copies on reserve. There's a number of very timely articles, and in terms of your own papers, there's there's definitely a ton of useful material to go through. On the web page, I've got a link, which I'm sure you guys have as well, to the law review page that contains a little bit more detail on the articles, because it's a little hard to see on the slide. Secondly, I knew that I wasn't the only one ranting on EULAs, but I'm greatly comforted to have found this book written by an awesome academic called Boilerplate, The Fine Print, Vanishing Rights, and the Rule of Law, which is essentially about what we've been talking about the last 3 weeks, and is quite aligned, I believe, with the discussion. And no, I haven't sent it to Rock Ripley, and I really should. Thirdly, I put this on the website and alluded to it last class. It was that I hadn't watched the Berkman Center lunch that was the day before our last class, but I suspected, because there was some pushback around this issue of do weak IP laws really facilitate creativity, I suspected that this talk might get around to that, and it does, and that's why I posted it. I also try to give you, if you don't have a lot of time, and I suspect that's increasingly true as the semester wears on, at least mention of where you might want to join into the core of this discussion. And you'll see this fascinating ambiguity where Nigeria's film industry, as opposed to, say, India's film industry, which is actually called out in the discussion, really thrived, and thrived in part because weak IP laws created a horizontal spreading of films, not all legally, but a real horizontal spreading of the fact that these films were being made, and some of them were good, and allowed for word of mouth and copying and the kind of viral effect that we see, and that has really supported the Nigerian film industry, which, by all reports, is a real breakthrough in terms of creativity. Of course, then you get the other side, which is as the industry becomes successful, that degree of illegal, and we're talking about straight plagiarism here. This isn't modding we're talking about or remixing. This is just straight people, the same distributor that you contract with for the 10,000 copies of the film that you want to sell legally also produces another 10,000 on the side, which goes into the black and gray market. So it's quite a wild scenario, and so the backlash is that they need IP laws. And of course, it's fascinating to see the tension, and I'm not saying it's one way or another, but it well expresses the tension that exists, showing that less IP law does facilitate creativity at the beginning, perhaps, and then impedes profit as you move forward. 1, 2.
I guess for those of us we're just an IP class, Mr. Justice Mason from the federal court was visiting to lecture about IP, I guess trademark enforcement and clerking with the court. Anyway, he was making a connection between IP infringement and organized crime, somewhat similar to what you're saying. You know, a lot of the infringement, especially with trademark increasing. Perhaps, but there's this. I think there is a strong connection, at least traditionally, between counterfeiting and that type of piracy and organized crime because of these tangible goods that are being distributed that are funding other operations. But then that same argument is being used to in the UK to have these anti-piracy, anti-torrenting task forces when there really is no connection or very, very few connections between piracy, online piracy, piracy video games, let's say, and
so obviously a very complex topic, but I'm going to try and parse it down very quickly, because a lot of this ends up being semantics. So one of the things that we've talked about in this class is the words intellectual property and the fact that they don't actually exist as statutory words. They are a label. Piracy is equally a label. It is not, you know, there is, it's semantic. It puts things in a certain light. Wholesale copying that has no creative impetus and doesn't add anything is one thing. Modding and remixing is another. One of the huge tensions in the area is that the kind of legislation that gets pushed for by the creative industries to stop, you know, wholesale DVD copying that adds no value ends up catching a lot of other stuff. And it's not surgical. And if you're a conspiracy theorist, you can suggest that maybe it wasn't intended to be surgical. And maybe it needs to be intended to be surgical. But that the wholesale copying without adding value is part of organized crime, or can be part of organized crime, I have no doubt of. And there's certainly that implication in the Berkman talk. And, you know, I'm not saying that law students have spare hours, but if you want to have it on in the background, it's an interesting discussion, certainly on this point. I wouldn't think of it as core to this course. But it's there, and also make sure that it's more permanently in the materials section.
Yeah, I was just going to say, so you've been approaching the idea of weak IP laws in that IP is a barrier to other people being able to build off of existing creations. Have you considered that IP also causes something called like the tragedy of the anti-commons, which have you heard of?
I have not heard of, so please
The idea, like in a film,
hit your button, because this is obviously educative to all of us, or to many of us, certainly.
Let's not get ahead of ourselves. So the idea of the anti-commons, so the commons is that you have one resource shared by everyone, and everyone abuses it, and it just gets depleted beyond any utility. Anti-commons is something like a film, where you might have a variety of overlapping different types of intellectual property, and because IP can be sliced and diced in so many different ways, you might have innumerable number of, well, not innumerable, but a large number of IP users all having rights in a different feature of one product.
Yes.
So if you want to, let's say, use that film in your YouTube short, you have to get permission from dozens, hundreds, who knows how many even you could.
Which is all but impossible
Exactly.
if you've ever done this work in a really practical way.
Exactly. So, or even in a video game, I think it was our guest last week was talking about all the different contract agreements they have.
Yes.
So if you want to use one of those EA games and they've signed 24 different contracts to license IP in different ways to build that game, your ability to be able to get permission to even lawfully do it is so difficult, it's virtually impossible. And I've heard that characterized as the tragedy of the anti-commons, where it's you have too many overlapping rights in incomprehensible.
So,
Or,
so I think in many ways, next week's class is going to be about this. But the really good news is that Jennifer Kelly in the second hour is going to be addressing these issues, I think, really directly, and will create, knowing her, some wonderful take-home value that we'll carry into next week. But the cases about, and these are video game cases that Jennifer litigates. But is this a copy? Is this game a copy of that game? Or is it sufficiently different? And how that goes. And that's really what we're going to be talking about. But I appreciate the definition of the tragedy of the anti-commons.
To a certain extent, that's also anticipated in discussions of network externalities, especially positive network externalities, when you're trying to talk about what would be appropriate remedies. For instance, piracy is a loaded term. It basically is based on the notion of exclusive ownership of property. I take your wallet, you can't use it anymore, or anything that's in it, therefore you are deprived. On the other hand, if we have non-rivalrous property, where I merely scan the information that's in your wallet and then I use it for something else, I may, in fact, actually increase the value of what's in your wallet with a network externality. And this happens quite often with the unauthorized works, the gray marketed sorts of things, where what happens is that in the determination of what the actual damages might be to the rights owner, there's not a lot of ways, there hasn't been a lot of ways anyway, of calculating what value added would go into that. Now, there is some economic theory on all of this, and it does deal with the idea of, again, network externalities, the fact that you make something more popular gives it additional value, and so the wider the use of your little program that you've designed or that you've created, the more likely it is it's going to be worth much, much more than it was before. When you get into a dispute over who owns it, whether or not you had authorization to modify it or do a variety of things, then the argument is going to have to be made, well, what are the actual damages? Under traditional sorts of approaches for infringement, we ask for things like an accounting of profits. We count up the number of pirate copies, and we multiply that by the full retail value, and that's the loss of sales. Well, that doesn't make any sense. From an economic point of view, it doesn't take into account elasticity of demand, that at half the price or a tenth of the price, you'll sell a whole lot more than you will if you have the whole thing. So it inflates the damages, and it's generally used by the rights holder to extract more from the infringer.
Can I ground that?
Yeah.
And not to cut you off, but the obvious example, and there's a lot that you will find on the net about this, and a lot of articles that have been written, is Game of Thrones. And there's a number of people who have argued, including, if memory serves, some of the people associated with Game of Thrones, that the unauthorized downloading of Game of Thrones served to hugely popularize it and create a halo around it. And what Ken's talking about is, okay, what if now the producers of Game of Thrones directly sued in relation to to get damages for the illegal copying? How do you measure the popularity that was gained as a result of that against the apparent damages? What would it have been as popular had it not been downloaded in an unauthorized way? And it becomes tautological precisely because, as Ken points out, when you're the lawyer looking for the damages, you're going to assume the popularity that it actually achieved and work backwards from there. So it's very tricky math, and to my knowledge, I have yet to see a case that really dug into this. But Ken, you may know of one.
Well, I don't know so much of a specific case, but let me posit this to you. There's all sorts of stuff around, I've forgotten the terms, but basically, you know, the sci-fi conferences and people dressing up in the costumes and taking on the personas of their favorite sorts of stars from the various sci-fi things or fantasy things that they might have done. Now, if in fact you had someone was protecting with their intellectual property rights the design of the of the costumes, the personas, protecting the personas that have been written as copyrighted sorts of personas, if in fact you had an action which was brought against those same people who dress up and go to all these conferences, the value of something as silly as an action figure of Mr. Spock from Star Trek or any of these sorts of things would be a fraction of what it is, because of the fact that these things have created cult followings, a whole new marketplace in many cases. And that's the sort of network externality that some rights holders are figuring out, that the publicity far outweighs what you would be able to get under the old business model if you're monetizing it that way. And one of the problems with IP is in trying to figure out, is this worth defending, or is this something that we should explore as another revenue stream or another way of tweaking our business model to sort of monetize what it is that we have created along the way. And you'll find that in new music in particular, this has been one of the issues. When you collect a variety of, you know, the collectives like SOCAN or whatnot, collect, the fee for the playtime, it all goes into a bit of a pot. And then how do you then determine who gets what out of it, out of all of the SOCAN members? Well, you go to the playlists. Well, there's an inherent bias there to established acts rather than to new acts.
So we got to move on from.
That's where you would see that there's a real conflict in how you go forward on these models. So it's not necessarily weak IP laws; it's changing models for monetization. Organized crime, well, they just happen to be out front. They're out front when it's drug or if it's alcohol. They're the people that are willing to take the risk in most cases.
Well, you know what? I'm perfectly willing to change the slide from weak IP laws to flexible IP laws. Moving on. The one thing to watch on this subject, it'll be interesting to see if the Olympics continues to grow in its popularity given their strategies around IP. I expect them to start holding steady and perhaps even shrinking. But that's a 20-year proposition. It'll probably surprise none of you that the slide that I put before you last week, for the first time, has grown and changed a little bit. I'm not going to talk about it a lot, but the basic theory remains and has now has become a 24-slide PowerPoint, which I have nowhere to present it, but at least I'm working on it. I won't give you the details other than I found a really wonderful John Perry Barlow quote that's supportive of the notions. And the notion, and anything that an ex-lyricist for the Grateful Dead says should be taken seriously. And the basic notion or statement that I've come to so far is concepts of law and justice do not shape communications technologies nearly as much as they are shaped by the memes and meanings arising from those technologies. So what I'm struggling with is the idea that we always find the law wanting when it comes to the wholesale change that digital has brought. And I'm thinking that may be a state of nature because the law doesn't come first. The law is informed by how we communicate. And and the memes and the methodologies and the technologies and the language of communication. And that, over time, is what creates the laws. And that's the theory here, that as we move through different technological memes, interestingly enough, whether it's correlation or causality, that certainly I don't know, the memes of justice seem to have changed. So that's what I'm working on. If anybody's interested, I'm very happy to have anybody look at the 23-slide deck because I need a lot of help as I work through it. So where are we? Today we finish connecting, and we move on to controlling next week. And we are going to focus on technology that connects. And this, with apologies, is the geeky talk. And it's not intended to be, but as I go through it, it's kind of inevitably so. I recognize that not everybody is geeky. We are fortunately getting to privacy and violence and other subjects that are less geeky. So, came across this slide. This is awesome. Please Google it. Just Google Hype Cycle for Emerging Technologies 2013. I don't know if anybody's seen it. It's a Gartner piece. It's very hard for you to read at a distance, but it basically has every technology and maps it in terms of kind of expected arrival dates, but also with a theory that every technology has an innovation trigger, a peak of inflated expectations, a trough of disillusionment, a slope of enlightenment where we're actually starting to use it properly, and a plateau of productivity. So, for example, predictive analysis and speech recognition are on the plateau of productivity. We're actually using these things now. But they started a long time ago somewhere down here at the innovation trigger. And it's as good a list of what's happening in the world as a world of technology as I've ever seen, all on one slide. And just in case you're wondering, what's closest to the new bioacoustic sensing and smart dust. So if anybody knows what those things are, bioacoustic sensing, I can sort of guess. So we're talking tech today. And there's a real-life law lesson which we can treat as metaphoric to the rest of the class. So I want to start there. It's a case called Magnavox and Mattel. On a personal note, the Intellivision was what got me through law school at McGill. So I used to play tons with my friend Peter, who ended up being our gold medalist. And we would play in television. I think in television, baseball and soccer were our favorites. And it's a strange and sort of apocryphal tale. So hold in your mind Magnavox versus Mattel. The Magnavox box is here. The Mattel box is there. So what did the Magnavox box do? You can forget the words on the screen. It played Pong, or what we think of as Pong. But by that hangs a tale as well. And this is just a description. I just love how judges describe games in words. It's a wonderful. Okay. So here's the chronology of the case. the first video game that we speak of most often is Space War. It's not necessarily the first video game. So you'll find websites dedicated to the question and lots of postings on what was really the first video game. That doesn't it doesn't affect what we're talking about at all. So for our purposes, Space War was a game created on a mainframe computer at MIT. It was actually, interestingly enough, a networked game. You could, it was not just a single-player game. The 507 patent, where did I go? The 507 patent, U.S. reissue patent 28507, is what we are talking about, was accepted in 1967-68 by a company called Saunders Associates, and Magnavox and Saunders entered into a license agreement in 71-72, and the Magnavox Odyssey, which was that box, was introduced in 72, and it had analog circuitry. It wasn't digital. And in 75, Atari introduced Pong. And in 76, General Instruments, another company, creates a TV game microprocessor. So digital for game boxes. And I need not tell you that Space War was digital from the beginning because it was on a mainframe computer. Then Magnavox sues Atari, who made Pong, for violation and infringing the concept of electronic ping pong, which Magnavox had before Atari did. You see, this is the magic of the trademark Pong, because we think of it as Pong, but Magnavox had it first. And Atari settled. And what's interesting, and again, you'll easily find articles about this, is that Pong, that we think of as the beginning of video games in so many practical ways, was arguably an infringer right from the beginning. So it wasn't original. So they settled, and Atari became a Magnavox exclusive licensee. Then Magnavox goes digital in 78, and Mattel introduces the Intellivision in 79, just as I'm finishing my civil law degree at McGill and staying on for my fourth year to get my common law degree, leading to 2 lost years, with a General Instruments microprocessor, and Magnavox sues Mattel. So 2 core things happen here. First, the court decides that there is no distinction between analog and digital. There, by the way, is a picture of the original MIT PDP microprocessor. I regard analog and digital circuitry as 2 means which are interchangeable and equivalent. So this is, if we're projecting, and remember, this is very difficult because it's not really entirely fair to look back at what a court did so many years ago when we know how the soap opera turned out. But so far, that's pretty good. No difference. But then I love this picture. I don't know if anybody's seen it before. Mattel says, you know what? What we did was not based on the 507 patent that Magnavox had. What we did was based on prior art. Space War, done at MIT on the PDP computer. And just so you know, the Pong thing is a bit of a red herring because this isn't about whether Mattel could have Pong on the Intellivision. It's much more a pure patent case around digital game consoles attached to a television set or not, attached to a screen. What the court did, which is easy to see as a mistake in retrospect, was go, oh, but, you know, we're talking two totally different things. A digital game box attached to a television is entirely different than a 20-foot computer, 20 by 20 computer, I forget the, 6 foot by 7 foot wide computer costing $120K sitting at MIT. These are totally different things. So you, Mattel, did infringe on Magnavox. And of course, from today's perspective, it's easy to recognize, and this is a bit, I don't mean it as a cheap shot against the court. It's easy to recognize that the 6 foot tall by 7 foot wide costing $120K was actually completely, and should have been completely irrelevant to the decision. So why do I tell you this? I tell you this because as we look at the future, which is what we're going to do for the rest of the class, it's really important to focus on how easy it is to make a mistake with your legal analysis, that somebody's going to call you on, some professor, so-called professor 30 years from now is going to say, wow, how could he have made that decision? Which is, again, completely unfair, but it does mean that the legal analysis is difficult. And that's the Santayana quote, those who cannot remember history are doomed to repeat it. So as we go forward, let's be mindful. So I just want to very quickly bring you to a definition in our Broadcasting Act. Broadcasting means any transmission of programs by means of telecommunications for reception by the public, by means of broadcasting receiving apparatus. Program means sounds or visual images intended to inform, enlighten, or entertain. So is World of Warcraft, if it is connected from your PC to what is called your television set, subject to broadcasting regulations? So this is where the definitional stuff gets very tricky. No one is suggesting that it is. Most people would suggest it isn't. But I invite you to keep staring at these words and seeing how easy it would be to move things from one category to another. And the reality is that defining certain screens as television and certain screens as other things is not making any sense anymore. And many years ago in this law school, when I was teaching media and communications law, and Ken will remember this, my first lecture, my first talk was I'd go up to the board. I had no idea how to do a PowerPoint slide. and I would draw 9 boxes. I'd say they're all televisions, and I would attach different apparatus to them. You know, a cable box, a VCR, a computer. You know, and I'd say, imagine your favorite movie, and imagine whatever your favorite movie is, it's playing on the same on all 9 boxes. And can you explain to me why all 9 boxes are subject to different laws and regulations? No, you can't. Well, that's what we're going to figure out in the course. That's almost archaic today. You know, it doesn't even make any sense. And that's what we're really going to talk about. So I just love this because nobody ever talks about this, and it may have just been a Freudian slip, but I find it interesting because I read it going through the official record. This is the CEO of Bell, who of course owns cable, owns CTV, owns a lot of media in this country, and talking about Bell's strategic vision is to deliver to Canadians content on all 4 screens: TV, laptops, smartphones, and tablets. So your PC, clearly they're not investing in the PC business. And not willing to say that Mr. Cope is wrong. He's kind of looking right. And I think he said that in, September 2012. So where are we in the battle? What's really interesting is that this slide has a couple of new players on it that weren't there last year. And I probably should have put them in yellow. So Xbox and Steam was there, although Steam has now added the NVIDIA Shield, which is a portable device, but will accept streaming from your computer to the device. So it's really quite cool. Apple was there. Ouya was not there. And Google just got there. And I didn't add a Google device, which I name here, Google Chromecast, which is new in the last couple of months. This is just what I've got going. And what it shows, without going into the details, other than I have an awful lot of stuff at the Center for Digital Media, which is probably a good thing. It shows that, at least for me, I'm not adhering to one ecosystem. And I don't think many of us are. I think Apple's predominant, but I think it may be starting to fall back. I'm not feeling the same way as I did about them. And interestingly, I haven't resolved it, but I'm leaning towards the PlayStation 4 as the first purchase. And I don't have a lot of Sony stuff here. So, you can examine your own habits. So when we talk about the future, it's nice to have, pardon the pun, a playing field. So how are we going to understand it? And sports has always been the go-to content that new technologies would define themselves against for a variety of reasons. And we don't need to get into the reasons, but I just want to rationalize why sports. And then there's this wonderful footnote. There's a great case called Canadian Admiral versus Rediffusion, which you should not be reading because it tells you what the law is today, but which you should be reading because it shows in much the same way as the Intellivision, the Magnavox and Mattel case does, how judges have to struggle in real time with new technologies, which actually goes back to the paper and the presentation I'm working on. And the fact that that conundrum may not be soluble. We're asking judges to do something that can't be done because the solutions get evolved in the system and the court can't really predict them. And the case there was the first live rebroadcast of a Montreal, again, sports, Montreal Alouettes game. So it was live. It wasn't being taped anywhere. Where was your fixation in that case? It was their copyright on the live broadcast. So that was, and the Copyright Act was amended to ensure that there was, but it's fascinating to see the court struggle with it. So this is why I use sports. Because as you go through the kinds of things that you want to see in a sports context, imagine yourself watching a Canucks game. All the things that you want to do, there's quite a lot of them. You want to know who's in the crowd. You want to have shared experiences with your friends who may not be local. They may be anywhere. They may be Canucks fans anywhere in the world. You want to be talking to them live. You want to be able to see all your replays. You want every camera angle possible. You might not get all these things, but let's just talk about what you might want. You want live feedback. You want Twitter feeds and other people's observations. And if people are live blogging, you know, if Trevor Linden was doing a live blog on a Canucks game, I sure would want to follow that. I sure would love to have his commentary as much as anybody's. And then, you know, obviously betting with your friends, calling them out. So there, second screens. There's a ton of live stats. There's a ton of stuff that you want. And then there's sort of the crazy stuff, which isn't so crazy. The fully immersive holodeck experience, which Microsoft, this is what they submitted for a patent. And you'll kind of see that it's Kinect-based if you look very carefully at the drawing. And they did a version of it, which I will refer to. And I have this fantasy that the roar of the crowd should also include the roar of the crowd at home. And that it should be, you know, piped into the arena should be the sounds of all of us cheering somehow, blended into that sound in a real way. Because that's actually more representative than what actually happens just in the arena. There's obviously a lot more fans outside the arena than in the arena. So those are crazy things. Legal issues. So I'm trying consciously to start with a manageable problem because we're going to quickly go right out of hand here. Sponsor conflicts and exclusivity. So now in this sports fantasy, which isn't a fantasy, which is happening and which will happen on the Xbox One and their deal with the NFL, which is merging all of these inputs onto one screen, which is really what the Xbox One does. You're going to have multiple sponsors at different places who, some of whom are the sponsors of the team, some of whom have bought time on the carrier, some of whom are associated with the game box, some of whom are associated with the services that you're merging onto the screen. So it is from a licensing perspective, a dog's breakfast. And that's the easy part. Now when you're merging all of these screens, you have different content from different places. Who's responsible for what? You know, if I'm the main broadcaster and I allow my content to be merged, am I somehow associated with some defamatory statement that comes across Twitter that appears on the same screen as me? I mean, probably not, but you start seeing that this gets complicated. And I don't believe a court would make the mistake of, applying kind of a lowest common denominator test. I believe they try and parse out the content. But because it's all on one screen, when you look at the definition of defamation, for example, you'll see that it considers the totality of the user experience. So it's not kind of particularly good at parsing out where the new technology takes us. And that's just one problem, is the defamation problem. And then there's a whole bunch of technical regulatory problems. A wonderful article by James Grimmelman, who used to be at New York Law School. I can't remember where he is now, on this subject, if you're interested. So you get what I call screen merge issues. And it'll come down to, in each area, privacy, defamation, copyright infringement, how does the rest of the content affect the specific content that's the subject of the suit? So that was the easy stuff. Now, we're going to get to the harder stuff, and then we're going to get to the really hard stuff. So the start of this was a game called Majestic, what I'm about to talk about now, and it's the notion of being inside the game. And Majestic was an EA game that was ahead of its time, and the tagline was, "It plays you." And it would send you faxes, because that was the technology at the time. It would phone you on your home phone. So it started merging the game world and the real world, so that you wouldn't know which was which. It was not hugely successful, but the vision of it. And then, of course, in terms of popular culture, this meme has existed in film for a long time, and I just threw out a series of films for, I think we've got some lovers of film in this class. And this is just a list of where we are now, and almost all of it merges the real world and the game world. And you'll see that the magic circle is either shrinking or expanding, depending on how you want to look at it. And from a legal perspective, all of this is made more complex by issues of privacy, issues of virtual goods, authorship, copyright problems. And I really want to focus, and I've put it twice in this presentation, Ryan Calo's amazing paper called Digital Market Manipulation, which is about what big data can do with a couple of good psychologists to get you to perhaps buy things, do things, engage in things that embody less than your free will. By measuring exactly where you are, knowing what your habits are, knowing when you're likely to be hungry, working through all of those things, and getting you to do, it's sort of the equivalent of what we used to think of as subliminal advertising, making you do something you don't want to do. And Ryan Kalos at University of Washington Law School, just south of us, and what he calls for is a great deal of vigilance with respect to consumer legislation to deal with this. So all that leads to kind of the big problem. I've talked about EVE Online. I've talked about Ingress, which merges the real world and Ingress and Google Glass together, creates a full-on merger between the game world and the real world. And what has happened in terms of a meme is that we've created a reversal. And that is, we used to take the real world, put it in a wheelbarrow, and shovel it into our computer screens or our TV screen through a game console. We digitize it, and then we process it, and it would show up in this world that we would kind of immerse ourselves into. And now we're seeing the opposite. We're seeing the digital world invading the real world. So we're not going from world to screen. We're now, in a sense, going from screen to world. And that's a huge change and has massive implications in terms of how the law will deal with issues. Because it's one thing to say there's a magic circle and the law shouldn't intervene, but when it's actually the real world that's completely implicated, it's hard to hold on to that argument. So what's next? I'm not kidding. Telepathic gaming. So I brainstormed with some colleagues at the Center for Digital Media yesterday. Give 2 more minutes. And this is what we came up with. Start with Oculus Rift or Microsoft's Illumini Room, and I will give you citations for all this stuff. Add physical player response measurements. So we're measuring your heartbeat, we're measuring your sweat rate, we are measuring as much as we can. Hopefully without too intrusive a technology. We certainly will eventually get to the fact that it won't be too intrusive. Right now, you probably have to wear something, but yeah, maybe it's smart dust. Exactly. Add neurogaming. So neurogaming's out there right now. No controller. You use your mind to control the game. Again, I'll give you several citations, one of which is this next one. Brain-to-brain interfaces. They figured out how to get, this would be really frightening, Ken and I to communicate with each other purely telepathically. There's also, I've added a citation for something that was just done, which is that people can actually visualize, other people than you can visualize what's in your dream. Which, again, takes you, talk about where Ryan Kalos' paper takes us. Add live stream, which is kind of full-on life data in front of you at all times. Add the ability to make things in the real world from the digital world, so 3D printing. Add a few remote control vehicles and drones for those of you who are wargaming oriented. Add monetization, which I don't think is virtual anymore, and then put it all into a Google Glass. And you think we have any issues? So I warned you earlier, in a sense, by talking about Magnavox and Mattel, that it's too easy to give easy answers. Now, that said, I'll go through an exercise next week where I'll give you a few opinions, but what I really want to do is give you actual citations for the things that were on that list because they seem so fanciful, and when you add them all together, they're actually quite real. And I put in yellow a couple of things, but breakthrough could enable others to watch your dreams and memories from Scientific American. And they actually have a picture of what the technology has thrown off as somebody's dream. And it's kind of frightening because you can actually see stuff. Which takes us back to not knowing what is real. I just like that picture of me not knowing what is real. I mean, why would you pose for a picture with a giant plastic thing? Which brings us back to our friend Nick Bostrom at Oxford and the question of whether you are living in a computer simulation. And the very real possibility as you track through what we talked about today that we really might be. So next week, we do controlling, and we're going to switch over to Jennifer Kelly, and there's my cat picture for the week, and we're going to take 5 minutes, and I'm more or less on time. Welcome to the class. I think you can see the class.
Yes, and can you see me?
Perfectly well.
Okay,
And we can see your slides.
great.
And you
Okay,
can't
well-
see me because it's in preference that you see the class. I think I'll just
Exactly, and I know what you look like, John.
yeah. Unfortunately for you, I'll sit in the front row.
Okay, so can you hear me all right?
Yes.
All right, so let's get started.
So I should just briefly introduce Jennifer. I've put it up on the website, but to my mind, Jennifer is the leading video game litigator in the United States. She's actually an excellent academic, and we are trying to encourage her to do more academic things. She came up last year. Unfortunately, she's got a ton of. She's in the midst of some litigation and couldn't come up this year. Otherwise, I know she would have. So over to you, Jennifer.
Okay, thank you, John. So the topics that I'm going to cover today are in this first slide titled Overview. I'm going to talk about the kinds of intellectual property claims that most commonly arise in U.S. game litigation. I'm not going to cover patents because patent litigation does not happen very often in video games, and it's not something that I do. I'm going to cover copyright claims, trademark claims, and right of publicity claims, which we're seeing a lot of. And then I'm going to talk about the analysis that applies when each of these subjects is at issue in these cases. I'll talk about the elements of the claims, the defenses, and I'm going to talk about some of the recent cases and some of the older cases, which lay a good foundation for the analysis that is used in today's cases. And just by show of hands, has anybody taken any basic intellectual property classes thus far? Copyright, trademark. Okay, good. Hopefully this won't all be too new to you, and you may have learned some of the basic stuff that we're going to go over. Of course, my focus is going to be on U.S. law. Before diving into the next slides, just a little bit more about me. I happen to be an avid gamer. I have been my whole life, all the way back to the days of Pong, which is probably something that none of you have played. It's a really, really old, simple game. And then leading into the Atari 2600, I grew up playing that all the way through the arcade-style games in the 80s, and then to today's modern console, the Xbox 360 and the Wii and all of that. I have all those systems at home. I play them all. I play social games. You name it, I play it. Which led me into this line of work because I have always had a passion for copyright law. It's an area of the law that is always changing, especially when new technology emerges. The law has to adapt to meet it. And there is so much going on in the video game space now, as you all know, that it was just a natural place for me to land. So I spend a large part of my practice is advising companies, advising video game publishers and developers about, during the game development process, how to avoid claims for infringement or wide publicity claims, to keep them out of trouble. I also advise them when they get a demand letter from a rights holder claiming that the game has crossed the line and violates some right, and often work with them as to how to respond to those sorts of claims or potential claims. And then I also, on the plaintiff side, do represent companies when their rights have been violated. I have a pending case right now that I'm going to talk about for King.com, which makes Candy Crush. Is anybody addicted to Candy Crush? Anybody? Just one person? Don't get started, because it will suck up all of your time and you need to be studying. But it's King makes a lot of great games, and because they have had such great success in that space, they're being ripped off right and left. So I'll talk about that case a little bit.
What a wonderful client to have.
With copyright claims, and I would say that of the current litigation in the United States, copyright tends to be the one that comes up the most often. This is when, and it applies when somebody comes along and makes a game that looks like somebody else's. So under U.S. copyright law in the U.S. is governed exclusively by federal law, which means if you've got a claim for copyright infringement, you've got to bring it in federal court, not in state court. And what copyright law protects is the expression of ideas, not the ideas themselves. You can get protection for ideas under patent law, but not under copyright law. Copyright law only extends to the creative expression that is wrapped around an underlying idea. So, in the video game context, let me back up. Under copyright law, generally, there is no protection for general concepts, themes, and genres, sans affaire, ideas merged with expression, and content that is not original to the author. So, to give you a little background on what that actually means, an example of a genre in the video game context would be, for example, the survival horror genre. Is anybody familiar with that genre? Okay. Can you give me an example of a game within that genre? Extra points for this. I don't think I can hear you.
Sorry, can you hear me? Nope.
Sorry?
Can you hear me?
Speak a little louder.
Can you hear me now?
I'm sorry, I can't hear.
Write it on a page and hold it up.
Say the game and I'll...
I can't remember the name of the game, but it's when you're running through the abandoned mall and you're grabbing things and the zombies trying to kill you. Basically, every zombie.
It's a zombie game.
Yes. Yes.
Tell us which one, Jennifer.
Well, there's a bunch of them. Dead Rising by Capcom is one that I know very well because I litigated a case involving that game. The Tomb Raider games also involve that genre. Does anybody watch the zombie show Walking Dead on AMC? That's also within that genre. There are certain elements of a genre. Video games, unlike any other literary creative work, are rooted in one genre or another. And so, for example, the survival horror genre involves certain elements like it's an apocalypse and they're survivors trying to stay alive, and they often barricade themselves in some kind of a structure and use whatever weapons and tools and resources they can find to keep themselves fed and sheltered and weapons and things like that. So nobody can own a genre. And so claims based on somebody taking, you often hear people talk about, well, they totally ripped off my idea. That's not a copyright claim. That's not a claim. Those things are free for the taking. Scène faire is a French term meaning the scene that must be done. So oftentimes genres have things that you expect to see. that are not protectable. For example, in the survival horror genre, in the zombie genre in particular, a lot of times a town is quarantined and there's barricades around the town. So you might not be able to drive a car out of town, but you would be able to escape the town in a helicopter. So I would argue, and I have argued, that the use of a helicopter as a means of escape is a scène affaire. It's something that you expect to see in a particular genre, so that's not protected by copyright law. The content not original to the author, this comes up a lot in video game litigation today because, everybody is copying everybody else. And so a very common defense is, you don't own what you claim I stole. You copied that from somebody else, and therefore you can't assert any rights in it. And I'm going to show you some examples of that as we talk about the cases. So in particular to the video game context, the kinds of things that are protected under copyright law would be the overall look and feel of the game, the way that you progress through a game. Something that is very common in today's social game is you progress through a series of levels, and certain things happen at each level. You get certain rewards and boosters and prizes at each level. And so there have been arguments being developed about how game progression can be protected under copyright law, much like in a book or a movie, you have a sequence of events that occurs, and that is something that historically has been well within the boundaries of copyright law. There's protection for graphics and for sounds and for the underlying code, although theft of code is not something that happens very often in the video game space. What you see happening is developers intentionally developing something that looks a lot like somebody else's game, but they're creating their own code. And with respect to instructions, much like game rules, they're not protectable unless they are basically verbatim copying. If you have a set of rules, there's seven, these are the instructions, there's 7 points, and you copy that verbatim, that's going to be a problem under copyright law. But taking those instructions and rephrasing them and putting them in a different format that's not going to give rise to a copyright claim. The other thing I wanted to talk about with respect to copyright law is stock characters is something that are not protected under copyright law. For example, in the Capcom had a game called Street Fighter that came out quite some time ago. It was a very popular arcade game, and that game was copied, and Capcom asserted a copyright claim and argued that the other game had copied, I think, 20-something of its characters. And the court said, these are stock characters. These are martial arts fighters. There's nothing unique about them. They're just characters that you would expect to see. They're stereotypical. That can be contrasted with the kind of characters that you might see in a AAA game built for the Xbox. For example, something like Brothers in Arms or Borderlands, where the characters are very well developed. They have names, they have personalities, they have certain ways that they act and they talk and they move. They're very distinctive. So when you have a character that's developed at that level within a game, that's something that can be protected under copyright law. So the elements of a claim, there's only 2 elements of a claim for copyright infringement. You have to be the owner of the work. And in the US, you actually have to have obtained a US copyright registration. You have to at least apply with the Copyright Office for registration. You have to own it, and then you have to establish that the defendant has copied protectable elements of your work. Meaning, they haven't just taken your ideas and certain elements that are not protectable, but they've gone beyond that, and they've taken your creative expression. And the defenses that often are asserted are copyright invalidity, independent creation, and fair use. An example of a copyright invalidity defense would be, you don't own it because it's not original to you. Somebody else before you came up with it. Or it was in the public domain. You don't own it. That's something that is very frequently asserted in video game litigation. Independent creation is, unlike in patent law, it is a defense. If two separate people were to come up with the same thing independently, and this guy was not copying this guy, that's not copyright infringement. That's not a defense that we see too often anymore, because in today's world where everything is available on the internet and everybody sees everything, it's pretty hard to argue that you didn't have access to somebody else's work. What happens more often is somebody is intentionally copying somebody else and trying to make it different enough to get away with not being sued for copyright infringement. So I have a few cases that I want to talk about, and I have some fun slides to show you. The first one is Atari versus North American. This is a rather old case. It involved a game called, well, Pac-Man. Who doesn't know Pac-Man? And a knockoff called Casey Munchkin. Casey Munchkin was developed by a company that wanted to put out a Pac-Man-like game for the competitor to the Atari 2600, which was a game device called the Odyssey, which is it's way before everybody's time here, but the
Not
Odyssey
mine.
was. Thank you, John. Did you play Casey Munchkin?
I don't remember playing Casey Munchkin, but it was so similar to Pac-Man that I wouldn't remember it.
Yeah. Well, what really made Atari mad was that Atari had a license to build a version of the arcade game for the Atari 2600. I think it's Namco that originated Pac-Man, so they got a license from Namco, and they were in the process of developing their game for the Atari 2600, and Casey Munchkin came out first. The defendant beat him to the punch, and Atari was pretty mad. So they sued, and they obtained a preliminary injunction, which may be why, I don't think the game was on the market very long, John, so maybe that's why you didn't see it. But the court found in this, the court was careful to draw the distinction between what was protectable under copyright law and what was not. And what it said was, no one can own the idea of a maze-based game. No one can own the idea of a maze that involves wraparound tunnels where you pop out one end and then you pop back in the other. No one can own the idea of dots, the use of dots to gauge a player's performance in the game. But they said that Casey Munchkin had gone too far because it wasn't necessary for them to use a gobbler. The court referred to the Pac-Man thing as a gobbler. It wasn't necessary for them to use a gobbler that had the exact same shape in terms of its mouth and the way that its distinctive gobbling action and the way that it collapsed back onto itself when it got eaten by a ghost. And so the court there found that Casey Munchkin had gone too far and infringed Atari's copyright with respect to the gobbler and the total concept and feel of the games. Because as you can see from looking at this slide, there are a lot of similarities in terms of the layout and just the overall impression, such that somebody looking at these games might not, of course, if they were like me, a Pac-Man guru, they would know immediately that this was not that, but the average person might not realize that they're not the same game. So Atari prevailed on that one. And this one, turning more to the modern era, this is these slides are from a litigation between Zynga and a company called Vostu, which people refer to as the Brazilian Zynga. It's a company based down there in Brazil. And Vostu came out with 6 games that were virtual clones of six of Zynga's games. They had, whereas Zynga had Cafe Mania, Zynga had Cafe World, Vostu had Cafe Mania. Zynga had Petville, Vostu had Pet Mania. Zynga had Zynga Poker, Vostu had Vosta Poker, and so on and so forth. And the games were really, really, really similar to the point where even the errors that appeared in Zynga's games appeared in the knockoffs. Where, for example, I think this slide shows you there is a road that is actually not connected, that's meant to be connected, and that error was also appeared in the ripoff. So Zynga sued Vostu, and there was some litigation that went on for a while, both in the U.S. and in South America, and ultimately it settled. And so there's not a court decision on this, which is Actually, the trend today is that most cases settle, and they settle early before there's a decision on the merits. So this is one of those where there was very active litigation, lots and lots of money being spent, but at the end of the day, they folded up their tents and called a truce. So Tetris and Nino. This case is, the name of the case is Tetris versus Zio Interactive, and this is also a relatively recent case, and this one actually did result in a decision on the merits in favor of Tetris. This case was interesting because the defendants in this case, who developed this game called Nino, which is short for Tetramino, which is the shape of the blocks that you see here, they argued that yes, we did copy. Yes, we intentionally copied. We tried very hard to make a game that looked like Tetris, and we wanted to build one for the iOS platform. But all we copied were the game rules. That's all, and game rules aren't protectable under copyright law. Well, the court did not agree with that and found that the defendant had gone well beyond what they needed to copy in order to create a block building game that involves the same rules that Tetris uses. And it said, for example, the things that they copied that were protected by copyright law were the design, movement, color, shape, and shading of the pieces, the dimensions of the board, which was 20 by 20, the previewing of the next piece to fall at the top of the screen, and the use of ghost pieces and garbage lines. And so the defendant went down in flames on this one. And I will add to that there has been a lot of litigation involving Tetris, both on the copyright side and on the trademark side. And you can pretty much be sure that if somebody copies Tetris, Tetris is going to sue them. So don't copy Tetris. They're very litigious. This is an example. This is another relatively recent case. The name of the case was Fry Fox versus Six Waves, and it was litigated in the Western District of Washington in Seattle. And this case had a relatively interesting background. The plaintiff, Spry Fox, developed this game, Triple Town, which is the one that you see on the right. And they entered into a development agreement governed by a non-disclosure agreement with one of the defendants in this case, LOL Apps, which was based here in California. And Spry Fox wanted LOL Apps to develop a version of their game for other platforms, including iOS. And the relationship broke down. And LOL Apps went ahead and developed this game on the left called Yeti Town. And the games were very similar, not so much necessarily in how they look, because as you can see, they involve different colors and different objects, but they had the exact same progression. Both games were on a 6x6 grid. And they're match 3 games where you take 3 items and you move them together, and then those 3 items become something else. And then you take those 3 items and they become something else. So you progress through the game hoping to get to the highest level. And meanwhile, you've got an antagonist trying to defeat your progress. In Triple Town, it was a bear. And in Yeti Town, it's this crazy looking Yeti over here. So in Triple Town, for example, 3 patches of grass becomes a bush, 3 bushes become a tree, 3 trees become a hut. In Yeti Town, 3 saplings become a tree, 3 trees become a tent, and 3 tents become a cabin. And so Spry Fox was understandably upset, especially since how they found out about it was one of their principals got an email from the guy at LOL Apps who said, I hate to be the bearer of bad news, but we're coming out with a match 3 game that's very similar in style to yours, and you're not going to be very happy about that. Well, they weren't, and they launched a lawsuit in Seattle, and the defendants, who by then were comprised of LOL Apps' acquirer, Six Waves, and I mention this because they're involved in a later case that I'm working on right now. Those defendants asserted the argument that what they had taken was only ideas. They had not copied an expression because, hey, look at how different the games look. And they brought a motion to dismiss. Which is it's a motion that says basically you haven't stated a claim. Even if everything that you say in the complaint is true, you can't move forward because you haven't stated a claim. And the court in looking at this, said, I disagree. I think that there's enough here that there conceivably could be a claim going forward. And even though I, see that there are not necessarily similarities in the way that the games look, the object hierarchy is the same, which I take to mean an argument that the game progression is the same. In terms of how you move through the game, it's similar at every level. And, LOL apps and Six Waves didn't have to do it this way. There were other ways that they could have done it. And so I'm going to allow the case to go forward. And so shortly after that decision came out, the parties settled, and SpryFox issued a press release announcing that the defendants had assigned all of their IP in the game to SpryFox. So just one little interesting tidbit about these two games. I have all of the games that I talk about and that I analyze and in connection with my work on my iPad, and I have an 8-year-old son. And he is always playing with my iPad. And one time he was playing Triple Town, and he ran out of lives. And he was like, Mom, can I go to the App Store? Can I buy some more lives? I want to keep playing. This is a really fun game. And I said, oh, just play Yeti Town. It's the same game. So he started playing it, and he goes, well, it is the same game. How can they get away with this? So I thought that was a rather interesting observation from somebody who doesn't know anything about copyright law. Okay, the next case that I'm going to talk about is another case involving Zynga. This one was Electronic Arts versus Zynga, and this case was brought sometime last year, and like most others, it was litigated aggressively at the beginning, and then the parties settled. But in this case, Zynga came out with a game called The Ville, which is the one that you can see over on the right here. And it was very, very similar to EA's The Sims Social, which, EA came up with The Sims long, long time ago. It's a very successful franchise. They have many different games on many different platforms. And The Sims Social was EA's version of The Sims for Facebook. And not too long after EA released that game for Facebook, Zynga released The Ville for Facebook. And EA made the argument that there were, they originated this genre, the life simulation genre, where the player is playing the role of somebody in a real life setting and pretending to be it's a fictional life and a fictional person, where you can create your character and you build their home. And EA argued that they had gone too far and they had infringed their copyright, in particular based on four similarities among others. One, the ability to create and customize a player's own character. Two, the fact that each player is given a similar starter home. Three, that the player's bodily needs are expressed in similar ways. For example, the way that they sleep and the way that they eat and the way that they interact with each other. Four, and that there were similar household activities that were going on. This was, John and I talked about this case when shortly after it was filed, because I first met John at a conference where this case had just recently been filed, and I talked about it, and we sort of talked with each other about, what do we think about the strength of this claim? And, my reaction was that it was a tough one for EA, because a lot of the similarities, yes, there are certainly similarities, and there was no question in my mind that EA intentionally came out with a game that was meant to be like, that Zynga came out with a game that was meant to be like EA's. But a lot of the similarities result from choices that are made by the player during the game. For example, you can see on the bottom images here, the kitchens look very similar with the purple wall and the way that the pieces are arranged, but those are driven by choices made by the player. So I can pretty much guarantee you that these images that we see here, which are pulled out of the complaint, it's what EA put together in trying to present their case. These are all the similarities that we see. That they were a result of a lawyer or a paralegal sitting in their office and let's find this image of this and let's make them look as similar as possible. So I'm not saying that EA doesn't have a claim or didn't have a claim, but I think it's tough. Historically, the courts have said when a game is, they have given more protection to games that are totally fanciful and not based on real life things like sports or, something like this, which is simulating real life. something like Pac-Man or Asteroids or Missile Command is more likely to get protection because it's sort of a made-up thing without any counterpart in real life, and there's no need for somebody to copy that. So I think that this probably would have been a tough one for EA. And for whatever reason, maybe neither side wanted to test the boundaries of the law. More likely it's because neither game turned out to be very successful. In fact, both companies announced that they were sunsetting the game shortly after the case was filed. The case settled, and so we never got a decision from the court on that. The last case that I want to talk about in the copyright context is the case that I'm currently litigating for King versus Six Waves. Six Waves was the defendant in the Tripletown, Yetitown case. And what we have alleged in that case is that Six Waves has gone too far in terms of copying two of the games that King came out with. There's Farm Hero Saga, and on the next slide is Pet Rescue Saga. Six Waves games are Farm Epic and then Treasure Epic. And all of these games are available on Facebook. As of today, Pet Rescue Saga is the only one that's also playable on iOS. But what we have alleged in this case is that the visual similarities are very, very strong, that there is very similar game progression throughout the levels, boosters being introduced at the same point. The way that you, these are match 3 games, the way that you join the pieces and the visual effects that you see when the pieces are joined. In Farm Heroes, they sort of fly off the screen, and there's a tractor that drives across and clears the screen. So what we have argued in that case is that that they've gone too far and they've infringed the copyrights. So their response to the complaint was due last week, and they filed an answer. They did not bring a motion to dismiss, and so now we are off to the races to litigate. And maybe at your if I do this lecture again for your next class, John, maybe I'll have more to say about this, about the way that this all goes down. But for now, stay tuned.
Because you're litigating it, I can't even make a crack about it probably settling like all the other cases do. But so
you can make a crack. I'm just going to remain stone-faced.
Exactly.
Will not respond. Okay, so let's turn to trademark. Trademark is governed in the U.S. It's governed by both federal and common law. Common law covers marks that are not registered with the USPTO. So you can get protection for a mark without a registration. Having a registration gives you certain evidentiary presumptions that are very favorable, so people often do register their marks here. And what trademark law protects is the use of a trademark name or a trade dress in commerce to identify a single source of goods or services. And what the focus of trademark law is, are consumers likely to be confused by your use of a mark, name, or a trade dress into thinking that you are the source of the goods rather than somebody else? And typically where this comes up in video game litigation is that somebody uses somebody else's trademark in the title of their game, either in the main title or sometimes as in a subtitle for the game, or they use the game they use the trademark within the game itself. And I'll give you an example of each of those. Using the name in the title is, Zynga has a gazillion games with the word Vil in it, and they've been very aggressive in defending the exclusive use of the name Vil in video games. And so there's been a lot of litigation, a lot of demand letters, a lot of disputes between Zynga and other companies over the use of the name Vil, Pyramidville, Mafiaville, Lucasville, Blingville. I'm going to talk about Blingville in a minute. The other way that this comes up is within the app, and a good example of this is in several years ago there was a case involving Grand Theft Auto 4. Grand Theft Auto 4, as I'm sure some of you know because it's such a popular game, is set in the fictional town of Los Santos, which is meant to resemble Los Angeles. And in developing the game, the developers included a strip joint called the Playpen, which was meant to resemble an actual strip joint in LA called the Pigpen. And so the owners of the trademark in the Pigpen sued the developers of Grand Theft Auto 4, arguing that the use of the Playpen obviously meant to connote, the use of Pigpen obviously meant to connote Playpen, and it was causing consumers confusion. and they lost that case. The owners of the mark lost that case because the court held that its use was protected by the First Amendment, which is a defense that I'm going to talk about on the next slide.
And were they concerned that people would go to the virtual bar instead of the real one? I mean, I'm trying to figure out what the source of the confusion actually would be.
Yeah. Well, John, the more I litigate, the more convinced I am that so much litigation is driven by emotion rather than logic. And you get people that get reactive about this kind of thing, and they bring lawsuits that they shouldn't. As we've seen in the recent Ninth Circuit cases involving Electronic Arts, NFL, Madden NFL, and the other game that involved the football players, claims under the Lanham Act, claims under trademark law face a much higher hurdle than claims for right of publicity because of this First Amendment defense.
Yeah.
That really, if you're going to parody something or use something in an artistic way that is not impinging upon somebody's right of publicity, you're probably going to get away with it. So turning back to the elements of a claim. So for trademark infringement, the elements are the use of another's mark or name in commerce that causes likelihood of confusion as to the source, sponsorship, or association. And a related claim under trademark law is this theory of dilution, that the use of another's mark in commerce that causes dilution to the strength of the mark. The argument being your mark is being used in a way that it makes it less effective in implying that there is a single source of goods in connection with that mark. So the defenses under trademark law that come up are classic fair use, nominative fair use, parody, First Amendment. Classic fair use is a defense that you're not using the mark in a way that is connoting source. You're using the mark in a descriptive sense. If you are studying in your trademark law class the same cases that I studied in law school, you may have heard about a case involving the mark fish fry, which was a mark that actually somebody did get registered, and they had established that it had special meaning within New Orleans. This fish fry spelled F-R-I. And another company came out with a similar spice that you put on fish when you're cooking it, called fish fry, and they argue, hey, this is a fair use. Did you say something, John?
Nope, that was a speak off.
Okay. So the court held in that case, you're not using this in a trademark way, you're using it in a descriptive way. And I'll give you another example of this, and this is more relevant to the video game context. This came up for me recently with one of my clients. I got a frantic call from one of my clients who had gotten a demand letter from a very well-known company that is known to be very aggressive in policing its marks about the use of their mark in connection with a vehicle in the game. And when they told me who the demand letter was from, I said, oh boy, this could be trouble. Let me take a look at it. Tell me more about how you're using the mark. And the way that what they told me totally changed my mind about whether there was a problem or not, because I said, gee, it sounds like the way that you're using this word is describing the vehicle and certain characteristics of the vehicle. Tell me about the color. Tell me about how fast it drives and what terrain you want to use it on. And so they explained all this to me, and I said, okay, give me 10 minutes. Let me play the game, and I'm going to call you right back. And so I called them back, and I said, you can take that demand letter and you can throw it in the trash because you're using it in a descriptive way. There's no way they can prevail in a trademark claim, and so we can all just move on. First Amendment is the other one that comes up a lot in video game litigation. It was what came up in the Grand Theft Auto 4 case and some of the other ones that we're going to talk about. And there's two elements to prevailing on a First Amendment defense in this context. If you can show that your use of somebody else's mark has artistic relevance to the work and is not explicitly misleading consumers as to the source of the goods, then it's likely going to be protected by the First Amendment, and you can go forth. let me give you one more example of the way that the First Amendment defense comes up. This was another case that I had that did not involve video games, but it's a good example of this. There is a small museum in Burlingame, California, that is run by a guy who has just dedicated his life to Pez, the candy, P-E-Z, and he had specially commissioned this 8-foot tall sculpture that was meant to look like a giant Pez dispenser. And he titled it "The World's Largest Dispenser of Pez." And he had a disclaimer on there that said, not affiliated with Pez the company, in no way claiming any affiliation. And Pez sued the museum and said, among other things, the sculpture is violating our trademark rights, and you've got to destroy it. So we represented the museum, and we argued that, hey, look, this is a clear case of the First Amendment. The use of Pez has artistic relevance to the work. It is meant to look like a Pez dispenser. It is an homage. The guy loves Pez, and he's expressing his love for Pez by having this sculpture. And it's not explicitly misleading because he disclaimed any affiliation. And nobody's going to think that in the context of the museum and where it is and how it's marketed, that this was something that was created by Pez. So that case settled right after we brought that motion, so the court didn't rule on it. But that's a good example to get you thinking about how the First Amendment can come into play in any context that involves trademark. So there's 3 cases that I wanted to talk about here just briefly, because we're getting short on time. There was litigation that Hasbro filed against a company called RJ Softwares that came out with a game for Facebook. I think it was in 2007 that it first was posted on Facebook, called Scrabulous. And it actually looked very, very, very similar to the game Scrabble. The boards were very similar. The gameplay and style were very similar. And so there was a copyright claim in that case as well. But this was an example of this would have been a pretty strong case, because Scrabulous is obviously meant to be a riff on Scrabble, and people were probably confused about this. So this one did settle, but it resulted in RJ Softwares changing the name to something else. And they also agreed to make some changes to the gameplay. One of the ones that I find very interesting is that they agreed to use, a player would have, instead of having 7 tiles at any given time, they would have 8. And what I learned from this is that was not an inconsequential change, because apparently the brain can really only handle 7 tiles at a time, and it's much harder for the brain to come up with words when it's got 8 tiles in front of it. So there was a lot of complaint from users who said, gee, the game is it's a lot harder. And the reason that I raise this point is because one of the things that I do when I talk with game developers about why they made certain decisions in the development process. Why is your game board laid out like this? Why do you have a timer? Why do you have 3 bars over here? What do all these things mean? Why do you have a 6x6 board? And what I often learn is that these decisions are not just aesthetic. They are functional. And so you can often make an argument that the similarities that you see between 2 games are functional rather than being purely, I didn't choose this because I copied you. I chose this because it's really the only effective way to do it. And that's an argument that is likely to succeed in court. So we talked about this one briefly, where Zynga has sued a lot of people over the use of the name Vil in the title. There's another one where the Learning Company, which has a game called The Oregon Trail, sued Zynga when Zynga announced that it was coming out with a game called Frontierville's The Oregon Trail, which the games were very similar. They involved a family traveling across the country in a covered wagon on their way to explore the West. And there were similarities in a lot of things that the characters did. And before Zynga agreed to take the Oregon Trail out of the title. So the last subject I want to hit on briefly is the right of publicity. And the right of publicity is a creature of state law. So usually the law of the residence of the person with the claim, or the heirs of the person whose right of publicity has been misappropriated. It's a personal claim arising out of privacy law, and it gives an individual the right to have exclusive control of the commercial use of his or her likeness. Some important things to know here is that the person does not have to be famous, nor do they have to be alive. And it does have some overlap with trademark claims, and it could potentially be a very broad claim, and it's a very scary claim because the First Amendment is not applied in the same way in right publicity cases. You have to, in right publicity cases, show that your use of somebody's name or likeness is transformative in some way, and I'm going to show you an example of that in the next slide. And celebrities tend to be celebrities and their people tend to be quite fierce in protecting their people's rights. And so when I have a client that says, "Gee, I want to build a game based around this person, or I want to use this person's likeness, or I'm going to make it so that you can't. It's not obviously that person, but you can tell it's that person." I'm like, whoa! This makes me very nervous because it's the right publicity claim can have a lot of teeth. Okay, so one example of right publicity was in Kirby versus Sega, which involved a game that Sega developed called Space Channel 5. And Lady Miss Kier was from